Good morning. Happy Friday. There has been a couple of times now in the last week or so that the right of access, the right to access, has been brought up either in my comment section or on Discord. And I want to clarify what the right of access is, the right to access is, as compared to, for example, your right to be present on public property, or on property that's open to the public, I should say, to clear up any confusion, and the right to record. Now, if you look at, for example, Turner v. Driver or one of the other decisions on filming the police, you'll notice that they talk about a right to record the police. They're pretty specific about what they're talking about, a right to record the police. If they're not talking about a right to record the police, if they're talking about, say, a right to access, then that's something different than a right to record. Different words, different things. In the law, we're pretty specific about the words we choose. That's why that whole confusion over, cops have no duty to protect. What does that mean? Well, it means that there's no legal recourse to sue them for money under the 14th Amendment if they fail to protect you. That's a very specific thing. And just like that's a very specific thing, the right to access is a very specific thing. And the right to record is also a very specific thing. So let's talk about the right to access. What is the right to access? Generally speaking, you have a right under the First Amendment to be present at certain government functions. Public executions, you have a general right to be there. Court proceedings, certain court proceedings, I should say, like criminal court proceedings, you have a general right to be present at a criminal trial. City hall meetings, county council meetings. So any kinds of meetings that are public meetings, public gatherings, you have a general right to be there. And the reason for that, it's based on the First Amendment. It's based on the right of the citizenry, not of the press, but of the citizenry to gather information. And you're going to say, well, that's a right of the press. Well, yeah, but the citizens are the press. And, the press can do its function either by being a citizen present and writing down what they see and then later on publishing that, or a member of the accredited press can talk to one of the citizens who is present and get their understanding of it and then publish that. But it's a right to gather information. Now, that right to gather information, and in fact, the entire right of access, is not without limitation. The court can, for example, seal a particular criminal trial. Why? Well, they would have to have a good reason to, and you may be able to sue to get access. And another court would look at it and say, well, either the court was right to do this, there's enough reason for the court to want to make this a private issue, or there's not. And so your interest, your right to access outweighs the due process, whatever the court was trying to do. Now, you always have a right to access. Even if your right to access is restricted, you have a right to access. People seem to talk about these things like the government takes away your right. They don't. They limit your right. They restrict your right. And they have to do that under certain circumstances. So there's a test. It's the Richmond newspaper test. I'm not going to go into it, but there's a whole test on when they can limit your access to these certain government functions, like court and things like that. Your right to record is also not unlimited, and it's also based on the First Amendment. Your right to record exists at all times. However, it can be limited. So you have a right to access a criminal trial. But do you have the right to bring audio-video recording in there to that criminal trial? Probably not. I mean, you can ask the court if the court will allow you to bring it in there. But the default state is it's forbidden. Because federal courts especially have determined that it may impair due process, the efficient administration of justice. It may cause disruptions in the court, things like that, to have people audio and video recording. And going back to my previous videos on why it's useless to record in court, the court also wants there to be one official transcript. Now, I know all of the all of the sovereign citizens out there, all of the people who just have a blanket distrust of the government are going to say, oh, it's a conspiracy. It's a conspiracy so that the judges can manipulate the transcript. Well, judges aren't the ones who are doing the transcript. And you could probably get your own court reporter, i.e. go to there's businesses out there that have court reporters, and you could have one of them come in, one that you've hired to come in and do a transcript as well. But the court wants an official transcript. And they don't want to have multiple transcripts because what the court reporter hears is what goes on to the transcript. And what a recording hears might not be the same thing as what the court reporter hears. The recording might pick up things that the attorney is saying to the client, or things that opposing counsel is saying to his client, or whatever. So it's not the same thing, which is a big reason why if you have an attorney, your attorney probably won't want you to record, because if you later try to use that recording, it's going to have picked up everything that he said to you, everything that is confidential between the attorney and the client. And I'm using that. There's a duty of confidentiality that the attorney has to the client. And there's also the attorney-client privilege, which is an evidentiary restriction. But if the client wants to use that recording in some way, he would have to supply the whole recording. He wouldn't be able to redact it before. I mean, the opposing side will probably have a right, most likely have a right to the unredacted recording. And then there would have to be a big fight about, well, this part contains, privileged information or confidential information between the attorney and the client, and it should be a big hullabaloo. Anyway, I'm getting off subject. Your right to record can be limited, and your right to access can be limited, and they're two separate and distinct rights. Now, you also have a liberty interest based on the 14th Amendment to be at places that are open to the public, which is different than a right to access, because a place that's open to the public is much more expansive than a government meeting, like a court proceeding. A public park, you can't be trespassed from a public park without notice and an opportunity to be heard. Notice and an opportunity to be heard. They don't have to give you a hearing. They have to give you the opportunity to have a hearing, which is different. It's a bit different. And how they do that is up to them. But that's kind of the baseline. And that's not based on the First Amendment. That's based on the 14th Amendment, the Due Process Clause of the 14th Amendment, your liberty interest. So right to access means that you have, generally speaking, a right to be present at government functions that are open to the public, generally speaking. It's not unlimited. And they may be able to restrict how you gather information. You may be restricted to writing notes down. There may be a single camera present, and you have an opportunity to get a copy of that video or something like that, or it may be published on YouTube, or you may be able to purchase a copy, whatever. There might be restrictions placed on how you gather information. And it is completely separate and distinct from your right to record. And I think tomorrow, probably, maybe this afternoon, I will discuss your right to record, specifically in the light of the Turner and Glick and Cummings decisions, and why, in my opinion, they are based on the public forum doctrine. And my camera just did a weird thing. Anyway, thanks for watching. You have a great day.